2026 ballot measures. The following ballot measures have been certified for the August 4th, 2026 primary election. Amendment 5. Official ballot title: Shall the Missouri Constitution be amended to require a legislative phase-out of the individual state income tax based on revenue growth and authorize the expansion of sales and use taxes? Curtail constitutional limits on taxing goods and services and require local tax rate cuts without reducing school funding if local sales tax revenue increases. The proposal has no direct impact on state or local tax revenue. If passed, implementing legislation will have an unknown impact to state and local tax revenue. If implemented, state government entities expect a reduction of $57,000 annually in income tax checkoff donations and implementation cost of at least $100,000. A yes vote will amend the Missouri Constitution to require legislative phase-out and elimination of the individual state income tax based on revenue growth and authorize the expansion of sales and use taxes, curtail constitutional limits on taxing goods and services, and require local tax rate cuts without reducing school funding if local sales tax revenue increases. A no vote will not amend the Missouri Constitution to require a legislative phase-out and elimination of individual state income tax based on revenue growth and will not authorize the expansion of sales and use taxes. At this time, the impact on taxes is unknown. Okay, let's get to the document here. The second, I thought I was able to highlight this last time. Second regular session, truly agreed to and fully passed. Senate substitute for Senate committee substitute for House committee substitute for House joint resolution 173 and 174, 103rd General Assembly, 2026. Submitted to be qualified to the qualified voters of Missouri an amendment repealing Section 4D of 26 and 26 of Article 10 of the Constitution of Missouri and adopting two new sections in lieu of. To be resolved by the House of Representatives, the Senate concurring therein. That at the next general election to be held in the state of Missouri on Tuesday next following the first Monday in November 2026, or at a special election to be called by the governor for that purpose, there is hereby submitted to the qualified voters of this state for adoption or rejection the following amendment to Article 10 of the Constitution of the state of Missouri. Section A, Sections 4D, and 26, Article 10, Constitution of Missouri are repealed, and two new sections adopted in lieu thereof, to be known as Sections 4D and 26, to read as follows. Section 4. 1. In enacting any law imposing a tax on or measure by income, the General Assembly may define income by reference to provisions of the laws of the United States as they may be or become effective at any time or from time to time, whether retrospective or prospective, in their operation. The General Assembly shall, in any such law, set the rate of or rates of such tax. The General Assembly may, in so defining income make exceptions, additions, or modifications to any provisions of the laws of the United States so referred to, and for retrospective exceptions or modifications to those provisions which are retrospective. 2. Withstanding any provision of this Constitution to the contrary, the General Assembly shall enact legislation to reduce and eliminate the state individual income tax by requiring reductions to the top rate of the individual income tax based on revenue growth until such tax is eliminated. Upon the elimination of the individual income tax, the General Assembly shall be prohibited from enacting or imposing any state individual income tax. Section 26. Section 26. 1. In order to prohibit an increase in the tax burden of the citizens of Missouri, state and local sales and use tax, or any similar transaction-based tax, shall not be expanded or impose taxes on any service or transaction that was not subject to sales, use, or similar transaction-based tax on January 1st, 2015. Subsection 2 of Section 26. 1. Withstanding any provision of this Constitution to the contrary, including subsection 1 of this section, for the purpose of reducing and eliminating the state individual income tax and reducing local tax rates, state and local sales and use taxes, or any similar transaction-based tax, may be expanded by legislation to impose taxes on transactions involving any goods and services. For the purpose of this section, the phrase, for the purpose of reducing and eliminating the state individual income tax and reducing local tax rates with respect to legislation enacted by the General Assembly means that the legislation expressly states the General Assembly finding that such legislation will directly lead to the reduction and elimination of the state individual income tax, as provided in subsection 2 of this subsection, and will directly or indirectly lead to the reduction of local tax rates as provided in subsection 3 of this section. Subsection 2 of subsection 2. Any expansion of the sales and use tax base or increase in the state sales tax and use tax rate enacted for the purpose of reducing and eliminating the state individual income tax and reducing local tax rates shall be offset in the same legislations by a reduction to the top rate of individual income tax that reduces such tax revenues, less refunds by an amount that is at least substantially equal to revenue generated by such expansions of the sales and use tax base or increase in the state sales and use tax rate. And any such legislation if such legislation is enacted within 5 years of the effective date of this amendment, shall not be considered new annual income for the purpose of Section 18E of this article, and shall be exempt from the provisions of Article 4, subsections 30B, 30C, and 30D of this Constitution. Subsection 3, subsection 1, subsection 1 of subsection 3. Notwithstanding any provision of this Constitution to the contrary, being 12 months from the effective date for legislation in which the General Assembly expands the state and use tax base pursuant to subsection 2 of this section, any political subdivision that imposes a sales or use tax shall, in the manner provided by law enacted by the General Assembly, make a one-time adjustment to one or more of the following rates of tax imposed by the political subdivision to reduce the amount of revenue generated thereby, and in an amount that is substantially equal to 97% of the additional revenue produced by any expansion of the sales and use tax base authorized by this section. A, the sales and use tax rate. B, the levy imposed on property in Class 2. C, the levy imposed on property in subclass 1 of Class 1. D, the levy imposed on all Class 1 properties if such political subdivision imposes a single rate of levy on all such property. Or E, the rate of any tax imposed on earnings. Subsection 2 of subsection 3. Notwithstanding the provisions of subdivision 1 of this subsection, to the contrary, no political subdivision shall adjust its local tax rate in a manner that results in any reduction in funding to any public schools within or serving to such political subdivision. Subsection 4. Notwithstanding any provision of this Constitution to the contrary, beginning 12 months from the effective date for legislation in which the General Assembly expands the sales and use tax base pursuant to subsection 2 of this section, each sales and use tax rate imposed directly by the Constitution, with the exception of the rate imposed under Article 14 of this Constitution, shall in the manner provided by law enacted by the General Assembly be adjusted in order to reduce the amount of tax in an amount substantially equal to the amount of tax produced by any sales and use tax base expansion authorized by this section. The state auditor shall be responsible for calculating the reduced rates that will go into effect as provided by this subsection. Subsection B. Pursuant to Chapter 116 and other applicable constitutional provisions and laws of this state allowing the General Assembly to adopt ballot measures for the submission of this joint resolution to the voters of this state, the official summary statement of this resolution shall be as follows. Shall the Missouri Constitution be amended to phase out the individual income tax based on revenue growth, reduce personal property and other local taxes when local revenues increase, modify the sales and use tax to eliminate income tax and reduce local taxes, and protect local funding for public schools and other purposes. And we have it signed here by the Speaker of the House and the President pro tem of the Senate. Okay, now let's look at what this is changing. Okay, let's go through the Constitution of the State of Missouri as found on the Secretary of State's website, which is where the ballot measures I'm going over are listed. And this was revised in 2025. So first off, we need to go to Article 10. Which begins on page 146. So Article 10, and in Article 10, we need sections 4D and 26. 4D is income tax laws, may incorporate federal laws by reference, rates, house set. Okay. And Section 4D states, income tax laws may be income tax rates may incorporate federal laws by reference rates, how set. In enacting any law imposing tax on or measured by income, the General Assembly may define income by reference or provision of the laws of the United States as they may be or become effective at any time or from time to time, whether retrospective or prospective, in their operation. The General Assembly shall, in any such law, set the rate or rates of such tax. The General Assembly may, in so defining income, make exceptions, additions, or modifications to any provisions of the law of the United States so referred to, and for retrospective exceptions or modifications to those provisions which are retrospective. And that is all that Section 4 says. And if you are watching this, looks like we are adding a subsection 2 to Section 4D. All right, now we need Section 26. Section 26. Prohibition on new or local sales, use, or other similar transactions based on tax not subject to such tax as of January 1st, 2015. In order to prohibit an increase in the tax burden on the citizens of Missouri, state and local sales and use taxes, or any similar transaction-based tax, shall not be expanded to impose taxes on any service or transaction that was not subject to sales, use, or similar transaction-based tax on January 1st, 2015. And to that we are adding subsection 2, which has 2 subsections to it, and subsection 3, which has 1 subsection to it, and subsection 4. And you can rewind the video and re-listen to those. What do you say we go find Article 4 and go over sections 30B, 30C, 30D. We also need to go through section 18 of section 10. Section 18E, voter approval required for taxes or fees when exceptions define definitions, compliance procedures, remedies. Subsection 1 of Section 18E. In addition to the revenue limit imposed by Section 18 of this article, the General Assembly in any fiscal year shall not increase taxes or fees without voter approval that in total produce new annual revenues greater than either $50 million adjusted annually by the percentage change in the personal income of Missouri for the second previous fiscal year, or 1% of total state revenues for the second fiscal year prior to the General Assembly's action, whichever is less. In the event that an individual or series of tax or fee increases exceed the ceiling established in this subsection, the taxes or fees shall be submitted by the General Assembly to a public vote, starting with the largest increase in the given year and including all increases in descending order, until the aggregate of the remaining increase and decreases is less than the ceiling provided in this subsection. Subsection 2 of Section 18E. The term new annual revenue means the net increase in annual revenues produced by the total of all tax or fee increases enacted by the General Assembly in a fiscal year, less applicable refunds, and less all contemporaneously occurring tax or fee refunds in that same fiscal year. This and shall not include interest earnings on the proceeds of the tax or fee increase. For the purpose of this calculation, enacted by the General Assembly, shall include any and all bills that are truly agreed to and finally passed within that fiscal year, except bills vetoed by the governor and not overridden by the General Assembly. Each individual income tax or fee increase shall be measured by the estimated new annual revenues collected during the first fiscal year that is fully effective. The term increased taxes or fees means any law or laws passed by the General Assembly after the effective date of this section that increase the rate of the existing tax or fee, impose a new tax or fee, or broaden the scope of a tax or fee, include additional class of property, activity, or income, but shall not include the extension of an existing tax or fee which was set to expire. Subsection 3 of Section 18E. In the event of an emergency, the General Assembly may increase taxes, licenses, or fees for 1 year beyond the limit in this subsection under the same procedure specified in Section 19 of this article. Subsection 4 of Section 18E. Compliance with the limit of this section shall be measured by calculating the aggregate actual new annual revenues produced in the first fiscal year that each individual tax or fee change is fully effective. Subsection 5 of Section 18E. Any taxpayer or statewide elected official may bring an action under any taxpayer or statewide elected official may bring an action under provisions of Section 23 of this article to enforce compliance with the provisions of this section. The Missouri Supreme Court shall have original jurisdiction to hear any challenge brought by any statewide elected official to enforce this section. In such enforcement actions, the court shall invalidate the taxes and fees which should have received a public vote as defined in subsection 1 of this section. The court shall order remedies of the amount of revenue collected in excess of the limit of this subsection, as the court finds appropriate, in order to allow such excess amounts to be refunded or to reduce taxes and or fees in the future to offset the excess monies collected. And then Section 19, since it's referenced in that section, we'll go ahead and read through it, and then we will read through Section 23 of this article since it is referenced as well. Section 19, limits may be exceeded when and how. The revenue limit of Section 18 of this article may be exceeded only if all the following conditions are met. 1. The governor requests the General Assembly to declare an emergency. 2. The request is specified as to the nature of the emergency, the dollar amount of the emergency, and the method by which the emergency will be funded. And 3. This General Assembly thereafter declares an emergency in accordance with the specifics of the governor's request by a majority vote for the fiscal year that says 1981 to 1982. Therefore, a 2/3 vote of the members elected to and serving in each house, the emergency must be declared in accordance with this section prior to incurring any of the expenses which constitute the emergency request. The revenue limit may be exceeded only during the fiscal year for which the emergency is declared. In no event shall any part of the amount representing a refund under Section 18 of this article be the subject of an emergency request. Okay, and now we need to go to Section 23 of this article. And we'll read it real quick, and then Section 23. Taxpayers may bring actions or interpretations of limitations, notwithstanding other provisions of this Constitution or other law. Any taxpayer of the state, county, or other political subdivision shall have standing to bring suit in a circuit court of proper venue, and additionally, when the state is involved, in the Missouri Supreme Court, to enforce the provisions of Section 16 through 22, inclusive of this article. And if the suit is sustained, shall receive from the applicable unit of government his cost, incurring responsible attorney's fees, incurring and maintaining such suit. Okay, so that should cover my first video pretty well without my little rant. I apologize again, especially for anybody's eardrums or speakers. When I played it through and reviewed it on my editing software, it did not get that loud. Later, when I watched it on YouTube, actually afterwards, yeah, it was loud. I'm sorry. If you would like to review this document for yourself, it can be found on the Secretary of State website, which is sos.mo.gov, under Communications and Publications, Missouri Constitution. I hope this helps everybody understand what we'll be voting for this year and what's going on with this Amendment 5. Seems to be that there's some confusion about it. Thank you for watching, and until next time, have a good day.